Hi, I'm Ryan O'Donnell.
And I'm Chelsea Razzo.
We are attorneys with Siegel O'Connor, O'Donnell & Beck, and we're here today to give a seminar called Preventing Workplace Sexual Harassment. Now, in 2019, sexual harassment has been one of the most important employment law topics.
And it's been one of the most talked about topics in the media at large.
People are more aware now than ever before of issues surrounding sexual harassment. Unfortunately, employers, as well as supervisors and employees, only know part of the story. A lot of folks have a general idea of what constitutes sexual harassment and what behavior could be interpreted as sexual harassment. Unfortunately, they don't know a lot of the legal issues, the specific technical legal issues regarding sexual harassment, and how those legal issues can be translated into common sense, everyday sexual harassment avoidance practices. While sexual harassment prevention training is always a smart idea, October 1st, a series of new laws went into effect that changed the obligations on employers with regard to employee sexual harassment prevention training. Because of these new changes, we've updated the training that we've been providing to many of you over the past several years. We've incorporated all of these new changes into today's material, and we're going to be walking you through what sexual harassment prevention looks like post October 1st, 2019 critical rule changes. So there's going to be several objectives for today's seminar. First and foremost, we're going to try to explain how we define sexual harassment, both from the legal standpoint and as terms of a day-to-day practical matter for supervisors. We're going to talk about identifying the different types of sexual harassment. There's actually more than one kind. And your ability to respond to sexual harassment complaints depends on your ability to recognize these different kinds of sexual harassment. We're also going to identify behaviors that may be interpreted as sexual harassment in the workplace in 2019. Behaviors that constitute sexual harassment and the scenarios that are considered to be sexual harassment have changed dramatically over the past 5 or 6 years, and we want to bring you up to date on all those important changes. So we're going to work to understand the contents of a good sexual harassment prevention policy. Documentation is critical, but so is making sure that our actions follow that documentation, whether it's policy or follow-up to incidents that happen in the workplace. And finally, and this is so important for supervisors, we're going to teach you how to respond and investigate to complaints of sexual harassment. As supervisors, you form the first front line between employee complaints and your company. Employee complaints are going to come to you first, and how you investigate and address those complaints will have a tremendous impact on the investigation going forward.
I'm going to go into the legal framework here. This is going to be pretty dry and pretty boring and a lot of legal jargon that I hope I can break down for you as brief as I can.
Chelsea, you're never dry or boring.
There are federal and state laws that prohibit sexual harassment in the workplace. For federal law, it's Title VII of the Civil Rights Act of 1964. There's also in Connecticut, Connecticut Fair Employment Practices Act, which also we call CFEPA. There are 2 agencies that work together or are responsible for enforcing these laws. Federally, it's the Equal Employment Opportunity Commission, or the EEOC. And in Connecticut, we have the Connecticut Commission on Human Rights and Opportunities, or CHRO. In Connecticut, employers of all sizes are going to have to provide supervisors with sexual harassment training by October 1st of 2020. Or if they've been hired after October 1st, 2019, within 6 months of their supervisory duties.
And that's a big change, is now every size employer is responsible for sexual harassment training, putting the burden on employers.
An even bigger change is that now employers with 3 or more employees have to train all employees, including your regular low-level employee, not just your supervisors and managers anymore. That training also has to be done by October 1st, 2020, or again, within 6 months of their hire. The training has to be updated every 10 years by your employers. It doesn't necessarily have to be this 2-hour again, just a supplemental update of any changes that are happening in the law. And lastly, any employee, including supervisors, who have been trained already since October 1st of 2018 are exempt from being retrained under this new law. There are also new Connecticut requirements If employers have 3 or more employees, they have to send a copy of their sexual harassment notice and policy to employees via email within 3 months of hire. You only have to do this if, one, you've given your employees their own email address through your company, or if that employee has provided their personal email address to you. Your subject line has to include something to the effect of, this is sexual harassment notice or sexual harassment policy contained here. Under changes in Connecticut law, the employees now have 300 days to file their discrimination or harassment claims with the CHRO. That's a big change. It used to only be 180 days, and now employees have almost up to a year to file claims against an employer. To satisfy the state's administrative remedy requirement, alleged discriminatees must bring their claim before the CHRO. If they're not satisfied with the process, they can withdraw their claim and file suit in civil court.
And Chelsea, let's talk for a second about that new 300-day timeline. What's really important about that is that people's memories tend to fade. I can barely remember what I did last week, let alone what I did this morning, really, as opposed to what I did 280, 290, 299 days ago. And so, frankly, from our perspective, the trouble with increasing the amount of time for folks to bring claims is that memories tend to be less accurate than they were when the event initially happened. So there's 2 things here. I think it really speaks to the importance of documentation, right? Because witnesses tend to come and go. Perhaps somebody who was a witness is no longer with the company at the time this person brings their claim. This is why documentation is so key. You can't predict where things are going to, be in 300 days. So a great way to guard against that is to take lots of documentation and contemporaneous documentation, right? Document the event when it occurs, not months after the fact. Certainly not once you know that litigation might be coming down the pike. You should be prepared.
Right. And doing something as simple as sending an email, so you get your date and time stamp, that helps.
And that is so important. Sending an email through the network is a way to prove that you wrote your documentation about an incident out well in advance of any litigation.
Another really important change in the law that supervisors and employers need to be aware of is that as of October 1st of this year, the CHRO is now entitled to enter an employer's business during business hours to ensure compliance with posting requirements. They can review all of your records, policies, procedures, and training materials. There are some limitations on this new rule. The CHRO has to reasonably believe that the employer is in violation of certain legal provisions, or they're allowed to come in during a 12-month period following the date on which any complaint has been filed against an employer. The CHRO process. How does the commission process a discrimination complaint? So a phone call, a letter, or any visit to the CHRO office starts your process. An interview with an intake officer will be scheduled, and they help you or assist you file your sworn complaint. Complaints have to be filed within 300 days now. Again, that's a change from the 180-day rule, from the date of the alleged act of discrimination, or from the time that you were reasonably aware of this discrimination. Some discrimination complaints are also jurisdictional under federal law, and they also have the 300-day filing period.
Generally, though, the federal EEOC will delegate responsibility for investigating these issues to the state agency, in this case, the CHRO, and whatever finding the CHRO ultimately comes to, the EEOC, absent relatively extraordinary circumstances, will accept that finding and adopt it as its own.
So the response. So once you've filed your complaint, there are certain responses that the CHRO will provide. So there's an assessment review, which takes about 60 days. There's also mandatory mediation going to be between your employer and yourself. If you're represented, you can bring legal counsel, and if your employer is represented, they will as well, in trying to work out the issues without proceeding towards any further litigation. The CHRO will also do its investigation, collect discovery, and really try to figure out what the claims are and if there's any merit to the claims. There's also early legal intervention, which is where the CHRO is going to release jurisdiction and allow you to bring your claim in civil court. If they don't do that and they retain jurisdiction, they'll make their determination where they'll say there's a reasonable cause to find there was discrimination or no reasonable cause to find discrimination. And past that point, then you go to a public hearing or a trial.
And the thing that I think is so important to point out here is that this is a very lengthy process. And as we progress, we're going to get a little bit more into just how long this process takes. But I think one thing to keep in mind is that even after you go through all of these steps, right? The assessment review, mandatory mediation, the investigation, perhaps you're an early legal intervention. Once you reach a determination and you move to the public hearing, once all that's done, you still might wind up in civil court.
Which then can take another upwards of years to finish.
So as we walk through the CHRO process, the first thing is you've gone to the CHRO, you filed your complaint, now comes the response, right? And what happens is, so the complaint is served on the respondent, in this case would be the employer, the person or company charged with the discrimination. Now, the respondent must respond under oath within 30 days, unless they get a 15-day extension, so 45 days at the most. If the respondent doesn't answer, the commission may find that the respondent is in default. We advise avoiding default if at all possible.
Always respond.
Always respond. Now, within 60 days after the answer is provided by the complaint, the commission must conduct what's called a case assessment review. The purpose of this review is to determine whether the complaint, A, fails to state a claim for which relief can be granted, B, is frivolous on its face, C, names a respondent that is exempt from coverage, there's not many of those, or D, that the complaint and documents received indicate no reasonable possibility that further investigation will result in a finding of reasonable cause. If any of these four determinations are made, the complaint will be dismissed. And Chelsea, you and I both know that that does not happen very often.
It does not, but we love when it does.
We love when it does, but unfortunately, it's a rarity. Generally speaking, the complaints are put together with enough evidence, at least on its face, that the CHRO retains them and moves the matter forward. So continuing on with our conversation about the CHRO process, let's talk about mandatory mediation. Now, complaints that are not dismissed after the initial case assessment review are retained. And retaining a case, however, does not mean that the commission believes the complainant has been discriminated against. There's just enough evidence on its face for the process to continue. Now, here's where the mediator comes in. Before there's a finding of fact either way, the mediator is going to sit down with both parties and try to resolve the complaint. And that resolution could take a number of forms. It could be the employee comes back to work. It could be the employee gets some back pay. But in those circumstances, the employee usually has to sign what we call a universal settlement agreement and release. We don't want that employee to be able to raise additional claims after the mediation process, especially if they've been paid a small fee. The mediation process rarely satisfies either party, and sometimes that's considered to be the sign of a good negotiation outcome.
Parties are really meeting in the middle here. It's to avoid further litigation, so no one walks away happy. It's very rare that one side has won the lottery, essentially.
Right. You're going to walk away with an agreement that puts this matter to rest, but that leaves both parties feeling relatively unsatisfied. So, CHRO investigation. If mandatory mediation is unsuccessful, the commission will then move on to a full investigation. An investigator will be assigned to the case within 15 days. Now, as part of this investigation, the investigator may request documents, conduct witness interviews, issue interrogatories, or other legal means of investigations. Interrogatories are essentially questions that will help us get to the bottom of what really happened, to get to the truth. Now, the investigator could also conduct a fact-finding conference. Now, at the fact-finding conference, the complainant and the respondent come in. We usually start off in the same room, and then we break. One party goes over here, one party goes over there, and the investigator speaks to each party, tries to get a sense of what the crux of the matter is. And the investigator is really after a determination of credibility. And that's easier to get in a face-to-face environment like the fact-finding conference. The determination aspect of the CHRO process begins with the investigator reviewing the facts to determine whether there is what we call reasonable cause. Reasonable cause to believe that a discriminatory act has been committed as alleged in the complaint. So it has to match up with the complaint, right? Reasonable cause means, and this is a quote, a bona fide belief that the material issues of fact are such that a person of ordinary caution, prudence, and judgment could believe the facts alleged in the complaint. I told you this would be a fun seminar. It does not mean the law has been violated. That can only be determined after a public hearing. It simply means there's reasonable cause to believe the allegations in the complaint. So after conducting this investigation, the commission tries to issue a draft of its finding within 190 days. However, the law provides for 2 3-month extensions in making this determination. So you're going to get 190 days with a possible additional 6 months. As we noted, this is a very, very long process. CHRO process, the continuing saga. So you might feel like after you've gone through the public trial that you're finished, especially if you've been at it for 190 days, plus the initial 45 days, plus the other 90 days for merit assessment, plus the possible 6-month extension. However, there's more. You can appeal the decision. The decision can be reopened. There can be a release of jurisdiction from the CHRO, which allows the complainant to take their case to civil court. If you wind up in civil court, the process starts anew. While it's not the exact same process as the CHRO, it is also a very time-consuming process and a very expensive process. So there's really no easy resolution to any of these issues. So before we dive into exactly what sexual harassment is, let's start with the basics. Harassment in general. Well, harassment is an act committed by a person that makes another person feel uncomfortable, offended, intimidated, or oppressed. Now, Chelsea, those are some pretty vague adjectives. And part of our job for today is to help you unpack and figure out what some of these generic terms actually mean in a practical, everyday environment, not just a legal one. And so, of course, we're going to be talking about harassment and harassment in the workplace. Now, the definition of workplace is obviously dramatically expanding. The workplace is no longer defined as the 4 walls of the building in which you work. Thanks to things like social media and remote access computing, the definition of the workplace is now expanding dramatically. And what you do on your personal time maybe isn't as private or as personal as you might think. Now, I know we promised this seminar would be fun.
We did say there was boring parts in, though.
And this is one of those boring parts. But we're required by law to make sure that everyone watching this video understands the legal definition of sexual harassment. This is Connecticut General Statute, Section 46A-60, subsection A8. Sexual harassment shall be defined as any unwelcome sexual advances or requests for sexual favors or any conduct of a sexual nature when A, submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment, B, submission to or rejection of such conduct by an individual is used as the basis for employment decisions affecting such individual, or C, such conduct has the purpose or effect of substantially interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment. Now, if that's not fun, I don't know what it shows. That's the legal definition. That's the definition. If you look up the statute for sexual harassment in the state of Connecticut, that's what you'll find. As a day-to-day practical tool, it's not particularly helpful. So what we're going to try to do next is walk you through that definition and break it down in a way that everybody can understand.
So to break it down a little further, sexual harassment is unwanted and unwelcome attention directed towards a person's sexuality or sexual identity that becomes a term or condition of employment. There are really 2 types of sexual harassment. There's quid pro quo, or this for that. That's probably what you think of most commonly, and we'll get into that a little bit later. Or there's also this hostile work environment. which again, we'll talk about a little bit later.
So Chelsea, basically you're telling me that the sexual harassment definition can be broken down into 3 smaller subsections, right? There's unwanted and unwelcome attention.
Rep.
Basically about sex.
In some way or another.
Some way or another about sex that relates to your job. So how do we know if conduct is unwelcome and unwanted? Well, the first question we have to ask is there equal power between both parties? And this goes back to that sort of cultural notion of the definition of sexual harassment, which is an older man taking advantage of a younger female subordinate. Next question we'd ask is there equal initiation and participation between both parties? And a lot of times you'll see a situation where someone perhaps is telling an inappropriate joke or acting in a way that's inappropriate, and the coworkers around them feel like they have no choice but to smile and laugh along with the joke. It's unfortunate, but in 2019 you have a lot of single moms and single dads who are maybe the sole breadwinner at home. You have employees who are taking care of older relatives or older parents, or as the economy continues to tighten, folks who are picking up extra shifts or a second job on the weekends. And these are all people who are in relatively precarious financial situation. These are people who really need their jobs. And they're willing to put up with a lot of borderline inappropriate behavior and oftentimes some degree of sexual harassment because they feel like if they come forward, they could be at risk of losing their job. And so a lot of times, and the courts are aware of this, and they will look to, is there equal initiation and participation amongst these people involved in the complaint, or do we have one employee, generally a supervisor, initiating all the negative behavior and a group of subordinates simply tolerating it?
Back to quid pro quo. That's the this for that. That's when your employment is contingent on a sexual favor. So think of, if you sleep with me, I'll give you a promotion. If you don't sleep with me, I'm going to fire you. If that happens, the employer's only defense is that the sexual harassment just never occurred. We can't say, it happened and we took some steps to remedy it. We switched her desk. We moved her to a different side of the office. So everything's fine now. They don't have to talk to each other. That's really not going to cut it here. Some examples of this are if a supervisor lets their subordinate know they're going to be laid off unless they give in to their sexual invitations. Again, if you say we're going to give your subordinate a promotion if they give in to your sexual advances. But also if you are a supervisor and you discipline your subordinate who has ended a romantic relationship. So you guys were together, now you're not, and all of a sudden subordinate's getting less favorable performance evaluations, they're getting fired. That's going to put up everybody's red flags.
Mm-hmm. Supervisors, do not date your subordinates.
Ever.
Ever. Don't care if you're Jay-Z and Beyonce. Don't care if you're the Biebers, right? Do not date your subordinates.
It never works out.
It never works out. Maybe you're the exception. Maybe you're the exception. And if that's the case, one of you needs to leave the company, right? Because here's what's going to happen. Inevitably, I understand that there are the occasional exceptions to this rule, but generally speaking, people do break up. And a lot. And it's very difficult because that relationship and the breakup is going to spill back over into the workplace. And I don't care how compartmentalized you think that your personal life is versus your professional life. If you work with somebody who just dumped you, it's going to come out. Let me give you a good example of something that we see a lot. We'll take an employee, let's call her Lauren. Now, Lauren is a terrible employee. She's simply not very good at her job.
We should have fired her.
Should have fired her a long time ago. She begins to date Michael, her supervisor. Michael is in charge of giving Lauren her reviews. And as luck would have it, when they start sleeping together, Lauren's reviews and her performance evaluations go way up.
Best employee in the company.
It's incredible. What a turnaround. However, things change. Lauren meets somebody else from a different department and dumps Michael. Michael's very upset. And suddenly, Lauren's performance metrics plummet. Back down to, frankly, where she was before she started dating Michael. She's always been a terrible employee. but her record no longer reflects that. It reflects an employee whose performance goes up, and then when they break up with their supervisor, their evaluations go down.
The timing's just too suspicious.
And even if we can prove that she is now, what's most, and this is the importance of documentation, is that if we can go back and establish that Lauren was a terrible worker before she started dating Michael, then maybe we have a prayer. But odds are Lauren's been getting middling reviews the whole time. Generally speaking, we're overly solicitous with the way we review our employees. It's easier to give somebody a middle of the road mark than to come down particularly hard on them. So we have a situation here where there's a clear temporal correlation between Lauren and Michael breaking up and Lauren's performance numbers dropping dramatically. Perhaps she's even been suspended or put on a performance improvement plan. All of which might be justified had we done it before she started dating her supervisor. But as soon as she started dating her supervisor, we have a real problem here. With regard to why a supervisor should not date their subordinates, let's also bring up a recent trend in the law, which is third-party sexual harassment cases. What I mean by third-party sexual harassment cases is, let's take the two folks we had in the previous example, Lauren and Michael. They both work for company A. Lauren is now the supervisor. Michael's her employee. And soon a third employee joins the mix, Dan. Dan is a much better employee than Michael, but he's not dating Lauren, so he's not getting ahead, at least from his perspective. So Dan brings a lawsuit alleging that the only way to get ahead at company A is to date Lauren. Maybe that's true, maybe it's not. But he certainly has a strong case moving forward because by all appearances, that is why Michael is getting ahead and why Dan's being left behind. That's the kind of inferences that can be drawn by other employees if a supervisor is dating their subordinate, and it's a dangerous game.
Okay, so the second type of sexual harassment is hostile work environment. So, hostile work environment is defined as when speech or conduct of a sexual nature is so severe, persistent, or pervasive that 1, it interferes with an employee's work performance, or 2, creates an intimidating, hostile, or offensive working environment. So an employer is going to be liable for a hostile work environment caused by a co-employee if the employer knew or should have known of the harassment but unreasonably fails to stop it, or if no reasonable avenue is available. If a supervisor creates a hostile working environment, the employer is liable unless it exercised reasonable care to prevent and correct harassment and the accuser failed to take advantage of opportunities to avoid the harm. If the harassment results in a termination, there's no defense for the employer.
So hostile work environment, how do we get there? How do we determine whether we're dealing with inappropriate behavior or hostile work environment that creates sexual harassment? Well, there's some factors to consider. The frequency and severity of the unwelcome conduct, whether the conduct is physically threatening or humiliating or limited to offensive words, whether the conduct unreasonably interfered with victim's work, and of course, whether the harasser was a victim's supervisor. I like to think of a thermometer, and as the mercury rises, we move from inappropriate conduct or behavior up towards sexual harassment. Say at 100 degrees Fahrenheit, we hit sexual harassment. So what kind of behavior creates the situation for the mercury level to rise from inappropriate behavior to sexual harassment? Well, there's a couple examples that we can give you. They're no means exhaustive. So talking about sex or making remarks about another person's sexual activity or preferences, telling or posting sexually suggestive jokes, cartoons, or pictures. I don't care if your kid sent you the email, don't forward it around to everybody. Unnecessary or inappropriate touching. Sexual remarks about a person's clothing or body. Chelsea, I think it's fair to say you can compliment the shirt, but not the body part.
Right.
If somebody is dressed inappropriately for their shift, do not get into a discussion where you point out specific pieces of their anatomy. Just inform them that they're not dressed appropriately for work. If they need additional information, they can refer to the handbook. And if they still won't change, send them home until they're ready to come back dressed appropriately for work. That's the best way to handle it. Don't get into a back and forth about different body parts and things of that nature. Massaging, patting, the back rub, don't get lobster claws.
Hands off each other.
Hands off, no touching. Using demeaning or inappropriate terms, if you're old school, dropping the honey or the baby or the sweetie. Nope. Making sexually suggestive gestures. I don't know why you'd want to make a sexually suggestive gesture at work, but if you feel like it, go out back.
And close the door behind you.
And with regard again to how your employees are dressed for work, it's really important to rely on the guidance in the handbook about uniforms or appropriate dress for work. That takes the ball out of your supervisor's hands, and that they don't have to make the determination about whether someone's too sexy for work, which is asking for trouble, frankly. The handbook serves as a neutral guide that all employees can see in advance or at the time of an incident to understand that this is not a personal attack or a personal preference of the supervisor. It's simply following the rules as they're clearly stated in the employee handbook.
Okay, so for hostile work environment, it's really important to remember perception versus your intent. So sexual harassment claims are going to be analyzed from the perspective of whether a reasonable person would find the environment offensive and whether the victim actually found that environment offensive. In the contrast, it really doesn't matter what your employee or supervisor's intent was. It's not a defense to say, I didn't intend to offend Becky. I didn't intend to offend Tom. It really matters how Tom or Becky perceived it and if a reasonable person in their shoes would perceive it the same way.
Now, part of that reasonable person standard, it does take into account that person's industry or occupation. If you are a porn star working for Hustler, you're probably going to see some penises at work. That's okay. That's your job. However, if you work for Siegel, O'Connor, O'Donnell, and Beck, you should not be seeing any penises at work.
No, you shouldn't.
You should not. But courts recognize that there's some professions that have different standards.
A more realistic example would be a waitress at Hooters versus a waitress at Applebee's. The Hooters waitress has a more reasonable expectation of having tighter clothing on, more attention drawn to body image and your body parts, whereas at Applebee's, you're not really going to run into that issue.
I hope not. So let's talk about harassment by non-employees. And this is an issue that, particularly with regard to the restaurant industry, is getting a lot of traction as of late. So let's talk about the law first, and then we'll go into some examples. An employer is liable for sexual harassment of its employees by certain non-employees, customers, independent contractors, or other acquaintances, if the employer knew or should have known such conduct was occurring and failed to take prompt, effective, and reasonable remedial action. Now, the greater an employer's ability to control the non-employee's conduct, the more likely it is the employer will be liable for that third party's unlawful conduct. An example of third-party harassment is, let's say there's a waitress and she has her section and she has her regular customers, one of whom comes in every Friday, has the same meal every Friday and a drink, and is not an issue at all until it comes time to pay the bill. After paying the bill, he insists on putting his much larger than would be appropriate or normal or customary tip in this waitress's back pocket. He insists on doing this himself. Now, this waitress is young. This waitress needs the money. This waitress at first does not object to the older gentleman putting the tips in her back pocket. These are really big cash tips. However, over a period of time, she becomes less comfortable with this scenario to the point where she goes to the manager and explains how upset she is that this man will only give her a tip if he can place it in her back pocket. Now, the manager has a tough call to make. This gentleman's been coming to the restaurant for a decade and a half, and is a reliable customer with lots of friends. However, the manager cannot allow this activity to continue. So what does he do? Well, his first obligation is to make the harassment stop. However, in doing so, he cannot harm the victim, in this case, the waitress. So how does he handle this? Well, he can go one of two ways. One, he can move the waitress to a different section, ensuring, however, that she continues to get the tips that she would customarily receive from her section. So if she moves from a full section to a less populated section, we need to make sure that she's not suffering a financial harm. And then the manager himself can go take tips from this rather disgusting older gentleman. On the other hand, the manager could decide to throw the patron out. He has that discretion. However, and this comes as a surprise to a lot of people, especially employees themselves, the customer does not have to be told to leave. He doesn't have to get banned from the restaurant. The employer's obligation here is not to extract revenge on the customer. It's to make the harassment stop, and to make the harassment stop in a way that doesn't hurt the employee. Those are the two tenets of how to handle third-party sexual harassment. Stopping the harassment without hurting the victim. And by hurting the victim, again, we mean by moving them to a section where they get less tips, moving them to a different shift that's a less desirable shift, or putting them in a different restaurant where they have to travel a long distance to it. If it's a restaurant down the road, that's not as much of an issue as if they have to drive half hour or 45 minutes to a new chain.
A new location.
And the same thing goes for package deliveries, vendors, food delivery. If you own a restaurant and the food's being dropped off, right, and you have a harassment complaint against the driver or the delivery man, obviously you're not going to stop receiving deliveries, right? So how do you deal with that? Well, you can have a conversation with the driver himself or herself. You can call their place of employment and have a discussion with whoever owns your supplier. I'm sure that will get fixed pretty quickly. And if for some reason that still doesn't fix the problem, have somebody different interact with the driver. The courts recognize that a restaurant has to get food delivered. Businesses need the mail to come. And if you're having problems with third parties related to those tasks, you can't stop getting the mail. You can't stop getting your food, but you can have somebody else deal with the mailman, the UPS driver, the FedEx guy, the delivery man or lady. Ultimately, the employees don't get to choose the remedy. Employers simply must address the legal requirements of stopping the harassment and ensuring that in doing so, they're not harming the victim further. So moving forward, one of the key areas of sexual harassment prevention is to learn about retaliation, right? What is retaliation and what role does it play in this larger sexual harassment issue? Well, retaliation is any employment action that would discourage the average employee from complaining about discrimination or sexual harassment, right? It's illegal to fire, demote, harass, or otherwise retaliate against people because they file a charge of sexual harassment, they complain to their employer or other covered entity about sexual harassment, or they participated in sexual harassment proceeding, such as an investigation or lawsuit. And some examples of retaliation, right? Let's talk about the real world examples, Chelsea. We could see a change in hours, increased workload, exclusion from social functions.
This one we might want to talk about a little bit because it's a little tricky. So say every Friday, your supervisor and your direct team, you go out for happy hour drinks. Now you filed or complained of sexual harassment against your supervisor and you're no longer invited to those happy hours. That's retaliation.
And that drives folks crazy. They say, I want to be able to decide who I go to happy hour with and who I don't go to happy hour with. But unfortunately, for supervisors, they have different obligations. And supervisors need to hold themselves out to a different standard and recognize that they have a different role within the company, and that if they take action like excluding somebody from a social function, in the eyes of the law, they are acting as a direct extension of the company. And therefore, that would be considered retaliation.
So while it's understandable you don't necessarily want to go drink with the person who just filed a complaint against you, the best thing to do is you have to stop going to the happy hours.
A change in office or a workstation, you're being moved down to the boiler room, for example, or that the not as clever as you think suggestion that perhaps it's not the right cultural fit for that employee, or maybe they'd be better off getting a job at somewhere else.
It's never as subtle as you think.
It's never as subtle as you think. One of our favorite parts of this seminar is a section we call Myth versus Fact, where I throw out a commonly held myth regarding sexual harassment, and Chelsea debunks that myth. So let's start with myth 1. Sexual harassment, it's inevitable when men and women work together.
No. Interaction between the sexes is inevitable, but sexual overtures are not welcome or unavoidable.
Myth number 2. If you ignore sexually harassing behavior, it will eventually fade away or correct itself on its own.
Again, no. Sexual harassers are rarely going to stop on their own, and ignoring their behavior is actually going to be construed as encouragement.
Myth number 3. Some people ask to be sexually harassed.
You guessed it, no. Sexual harassment is a power issue, and being victimized by someone who, by virtue of their position, seniority, or physical size, is in a position of power over you is painful and difficult experience. She wore provocative clothing, or he enjoyed it, are unacceptable excuses for sexual harassment.
So now we're going to talk about some scenarios that I think illustrate a lot of the concepts we've been trying to discuss in today's presentation. We're going to walk through these scenarios, and Chelsea and I will comment on them as appropriate. So the first scenario is about a girl named Elizabeth who works as a help desk operator. She meets Mac, another employee. Now, soon after they meet, Mac begins to pester Elizabeth with unnecessary questions. He hangs around her desk. He starts to pressure her to have lunch with him. We see where this is going. Elizabeth consistently refuses. She's just not into Mac. However, Mac is not discouraged. He ups his game and starts to ask her to have drinks with him after work, right? She's trying to put him right in the friend zone. He's pushing right back out. And so each time he asks her, though, she's saying no, she's putting him off. She's clearly not interested. However, again, Mac is one persistent dude. So he starts to leave notes on her desk. These notes have little sonnets on them, love poems, notes. Some just say, I love you, right? So Elizabeth is shocked and frightened by Mac's persistent attention. She's not sure how to handle it, and one day it just reaches a head. She feels ill, and she goes home early. Now, at this point, Chelsea, what should we do?
Well, I think right here, our thermometer is definitely moving up. And we're definitely on the road to some sexual harassment. She has clearly made it known that these are unwanted and unwelcome advances. Mm-hmm. He's continuing to persist, and now it's starting to impact her work performance.
Absolutely. And this is where having a vigilant supervisor is so important. If you're a supervisor who's paying attention, a supervisor who knows or should have known what's going on with their workforce, odds are you're going to notice if Mac is not just hanging around her desk, but if he's leaving her notes, if he's leaving her flowers, maybe he's putting a flower on the windshield of her car out in the parking lot. These are things that are out of the ordinary. And if the law expects you as supervisors to pick up on them and take action. Now, what action do we take though, right? Well, it could be as simple as approaching Mac and asking him what's going on. That's one option. I would choose option 2 though, and that's going to talk with Elizabeth and saying, Elizabeth, is everything okay? Is everything cool with Mac? Now, whatever she says, we're going to document her response. We're going to email that response to ourselves or to HR or to both, so we have a clear record of our attempts to address this issue. Now, if she says yes, everything's cool, then great. As far as we're concerned, everything is cool. They're not supervisor subordinate. They're both, equal level in the hierarchy employees. So there's no concern about power differential here. Your coworkers can date each other as long as there's not that difference in power. So we're not going to really get involved at this point, but we now have a record that we approached Elizabeth about the situation, made sure that it was okay, and moved forward. However, if Elizabeth says, no, Mac is creepy and freaking me out, we can take action, right? We go speak with Mac, we discipline him, we tell him to leave her alone and make sure that they stay separated during the working day, right? But we didn't do that, Chelsea, so what happens next?
Well, so the next, Mac posts a comment of Elizabeth's Facebook page. I hope you're feeling better. I have enjoyed getting to know you so much over these past few months. Maybe I can bring over some soup. Elizabeth obviously freaks out even more. She quits and files a CHRO claim alleging sexual harassment.
Now, after she's filed this claim, again, we have no defense because we should have known this was going on. Obviously, we didn't know that Creepy Mac was going to roll over to her house with some soup or start following her onto Facebook. But that's a logical progression from his actions at the office, which we did nothing to stem, nothing to stop. So the CHRO is going to take the viewpoint of we didn't do enough to address a situation where we should have known there was a problem.
And as we talked about earlier in this, even though this is just on Facebook, those four walls of your place of employment are expanding, and they're going to include Facebook or other social media posts in this scenario.
Right. And I think you can see how the activity on social media blows back into the workplace. If he's posting on her Facebook wall, what, she's going to come back to work on Monday and forget all about that and not be scared of him? Absolutely not. There is a clear carryover from personal social media activity back into the professional realm. And while we're at it, this seems like a good time to tell all supervisors to unfriend your subordinates. I know that's harsh, but do not follow your subordinates on social media. Now, on Facebook, Twitter, Snapchat, Instagram, any of these new cool ones I haven't even heard of yet, don't follow any of your subordinates on any of those apps or pages because you're asking for trouble. You're going to learn things about your subordinates or see things about your subordinates that you don't want to know. For example, let's say that an employee wants to come out of the closet and they've decided to make that announcement to their friends and family on Facebook first before telling anybody they work with. However, you're their friend, but you're also their supervisor. You see this announcement that they're coming out of the closet on Facebook. Okay, great. You don't think twice about it. However, a month later, that employee gets terminated and he files a complaint with the CHRO claiming discrimination because he announced he was coming out of the closet and he did so on Facebook where you, the supervisor, saw it. Well, supervisor's knowledge is automatically transferred to the company. If a supervisor knows something, the company knows something. So even though the company made the decision to terminate this employee with no actual knowledge of the fact that they've announced they're coming out on Facebook, right? The fact that the supervisor saw it and knew is enough for this action to proceed forward. And people are just not understanding the way that this new media and change in privacy attitudes is impacting the workplace.
So second scenario, John and Tracy, who are advertising sales executives, they travel together on a week-long business trip. On the taxi ride from the airport to their hotel, John decides to shoot a shot and snuggles up next to Tracy and tries to hold her hand. Tracy objects, says, "Get off me," and John backs away. So over the course of their work-long trip, they attend meetings together. At the end of the week, they attend an evening meeting. John then asks Tracy to join him for a drink at the bar. Tracy declines. Is this sexual harassment?
Possibly. John made his big move, right? And I wouldn't have chosen the snuggle as my move of choice, but I've been out of the game for a long time. So maybe that is the way to do it now. I don't know. But it didn't work. It didn't work. John's big move in the taxi fell flat. So the problem is, though, even though John has backed off in theory, right? Anything he does is now seen through the lens of his prior decision to make a move on Tracy, right? He might want to just have a business meeting. They might have a presentation for the next day they have to discuss. There might be a valid professional reason for them to get together to have a drink at the bar. It could be entirely professional. However, Tracy is going to view that through the lens of John's romantic interest in her. And that's a problem. So you have to be aware of the fact that if you do try to cross that line with a coworker, there's going to be real long-term consequences, whether you intend them to be romantic gestures in the future or not. And that's something a lot of people don't think about. You're just thinking, well, if I snuggle up to her in the taxi cab, I'm in. You have to think 3 or 4 steps past that.
So final scenario, a delivery person keeps asking your receptionist out and brings her flowers. Your receptionist is not interested in dating this person. Is this sexual harassment?
If it keeps on happening and we don't do anything about it, sure. It can certainly reach up that thermometer towards the 100 degrees mark for sexual harassment. It's obviously, inappropriate for the delivery person to be hitting on staff. We can resolve that. We talked about a couple ways previously. We can either call the company for which the person works, have that conversation, take the employee out of the situation in a way that doesn't harm them or have any sort of negative impact on them. Or you can talk to the delivery person yourself as a supervisor and let them know that this sort of behavior is not acceptable. So, preventing sexual harassment. We've gone through some of the scenarios of what sexual harassment is and what are our obligations about it, but how do we prevent it, right? Well, there's a couple steps, and really like to think about questions to ask yourself, and sort of like a self-check. Is my behavior welcome? Of course, remembering our discussion about power dynamics and how those can influence how others react to your behavior. Would I behave the same way if my spouse or significant other were around? And sort of a different spin on that is, especially in this age of texting, social media, etc., would I send that text or message if my spouse or significant other were reading it? Would I want the entire office to know this about me? Would I want someone else to act this way toward my spouse, friend, parent, or child? And again, very important, is there equal initiation and participation between me and the person I'm interacting with? Am I the one telling all the dirty jokes and my subordinate is simply standing there pretending to laugh, smiling, looking uncomfortable? Are they ever making the jokes themselves? Are they ever initiating the behavior themselves, or are they simply putting up with it? So some tips for prevention. Again, if you observe sexual harassment, intervene and report it. If you're a supervisor, if you're brand new first day on the job, it doesn't matter who you are. In order to create the kind of culture that we need to have in 2019, we've all got to be pulling in the same direction. And that means being on the same page with regard to sexual harassment and how to report it, right? If you see it, say something, right? It sounds silly, but again, I'm sure I'm stealing that phrase from somewhere, but if you see something, say something, right? If you find sexually oriented materials in the workplace, take them down. I don't know why there would be sexually oriented materials in the workplace, but if there are, take them down.
There's no need for the funny pictures, funny memes. Just put that somewhere else.
All right, guys, that wraps up today's seminar, and if that wasn't fun, I don't know what is. But we appreciate your patience, time, and attention. I know this isn't the most exciting material on earth, but it's important that we go through it. Chelsea and I both really appreciate your time and attention. Importantly, very importantly, this is part of the new training laws that passed on October 1st. If you have a question regarding anything you saw today, or you just want to tell Chelsea and I how awesome we are.
We love hearing that.
We love hearing that. Can't hear it enough. Please send an email to the address on your screen right now, and we'll get back to you within 24 hours with a response to your question or a thank you note for your appreciation.